What is law enforcement's shake test, and is it admissible in Oklahoma criminal cases and forfeiture cases? I'm Tulsa attorney James Wirth, and that's the question that we have. This new thing that law enforcement is trying to do, a shake test, and whether that is worth anything, whether it's reliable, whether it is admissible, how they're trying to use it. Okay, so we've actually got a case. Normally we're reporting on appellate decisions because those have precedent that can be used in other cases, and even if they're not published cases, they can still provide good persuasive authority. But actually, in this time, I'm talking about a district court level case, so it is not technically precedent, but it's the first one where I've seen a really good opinion address this issue, so I want to talk about it. And it's actually in Garvin County, CF 2023-159. And the judge down there in Garvin County has a pretty good order going over these issues. It's Judge Leah Edwards. And one secret thing, a lot of times it's not the judges that draft their orders. And if for higher level courts, they've got clerks that do that. But in district courts, a lot of times they have the prevailing party draft that order. So I don't know if this was drafted by the defense attorney or if it was drafted by Judge Edwards herself. But in either case, it's got a lot of good information on how she handles this new issue before her court that other people dealing with this will want to utilize. So first off, what is the shake test? So in this circumstance, somebody gets pulled over. Law enforcement gets, pulls them over, searches, finds $14,000 in the car. And when law enforcement pulls you over and finds large sums of money, what I've seen from my experience in representing people is they want to snatch that money, they want to keep it, they want to use it to buy new police cars or whatever. They take that money, they try to forfeit it and use it for law enforcement and prosecution, budgets, pad those budgets. So what did they do here? Well, they took that money and then they put out a sheet of paper and then they shaked and flipped that money to see what kind of particles would fall out. Nothing that you can see, just kind of really tiny, small, and visible particles. And then they try to do a test on that paper. And if that paper tests positive for narcotics or CDS, well, then they're going to say, well, that money must be drug money. And if it's drug money, then that person that was possessing it is guilty of acquiring drug proceeds, essentially possessing drug money. And we get to take it and forfeit it to the state. So that's what they did here. They charged the person with possession of drug proceeds, and then they're trying to use this shake test as evidence. However, once they took that money and they did the shake test, they just deposited that money in the bank account. They didn't take it and preserve it so that independent testing could be done. So the defense team didn't have an opportunity to do their own testing. And they didn't provide a lot of foundation to show that this is a reliable test. So the defense had a motion requesting that this evidence be excluded, essentially requesting, Daubert testing. So Daubert is the test where we look at, is this scientific method that they're trying to do to this money, the shake test, is it reliable? Should it be admissible? And the first factor that you look at there is whether it has been long recognized as a proper test for expert testimony. And the court found that it hasn't. And if it hasn't, if there's not a long history of it being recognized, then we go through this three-part test, whether it's based on sufficient facts or data, whether it's a product of reliable principles and methods, and again, this is the shake test. Is it a product of reliable principles and methods? And the witness has applied those principles and methods reliably to the facts in the case. So the court went through that into the facts of this case, and the officer essentially testified that I was kind of taught this by some just other guys that we do it this way. So there was we didn't teach that at the academy. There's no training on it. There's no documentation on how it's done. So there's no way to see if the methods that they used are the proper methods. And essentially they failed across the board on this, just something that they made up. Moreover, there's a lot of evidence and studies that suggest that the majority, in some studies, showed the majority of money in circulation has trace amounts of narcotics on it. And in all of the studies that was provided to the court, at least 10 or more percent of the money in circulation has some trace elements of narcotics on it. So that if the money was, indeed, waved over, brushed over this paper, that it would not be unusual if you have, testing that is for drug testing that can get to the smallest kind of microbes on there. You would expect that it would test positive. So ultimately, the court in this case found that, there is no historical basis to show that this is reliable, that there wasn't proper, training, that we could show that this particular test was done in compliance with that. There was nothing demonstrating that the methods are accurate. So the court found that the burden is on the state. It's not on the defendant if it's on the person who's trying to bring in the evidence. The state's trying to bring in the evidence. So the burden is on them to establish this is reliable. And the court found that they did not establish that it was reliable. So if you've got somebody, law enforcement, using the shake test to try to forfeit your money or to charge you with possession of drug proceeds simply because you're traveling with a good amount of money, well, you're going to want to talk to an attorney about that. You're going to want to meet with them privately and confidentially to get legal advice, actionable legal advice specific to your circumstances. To get that scheduled with an attorney at my office, you can go online to makelawEasy.com.